Please be seated. Welcome to Division 6 of the Court of Appeals. I'm Judge Lipinski. With me today are Judge Freyre to my right and Judge Schutz to my left. We have three cases set for argument this afternoon, one at 1:30, one at 2 o'clock, and one at 2:30. I see counsel are here, presumably for the 1:30 case. Our counsel here for the 2 o'clock case as well. Is anyone here for the 2:30 case? No. And that's fine. I will provide my introductory remarks when they arrive. Do any of the attorneys have any questions about our procedures before we proceed with the arguments?
No, Your Honor. No, Your Honor.
Right, seeing no questions, let me just go over some of the preliminaries. As you undoubtedly know, counsel for the appellant can reserve time for rebuttal. Please let us know if you want to do that, but you'll need to keep track of your time. If you burn through your 15 minutes during the principal argument, you won't have any rebuttal time, so it'll be up to you to keep an eye on the clock. In addition, because of our technology, and I see we have our brand new technology in place today, but I understand that sometimes use of cell phones, laptops, tablets can interfere with the court's technology. So please turn off your phones, turn off your electronics. Don't just mute the phones, don't just silence them, but actually turn them off. In the second case, which is a criminal appeal, if there is any reference to victims, please refer to them by initial. As you know, we don't refer to juveniles or victims by name. We just refer to them by the initials. If we mispronounce any name, please let us know. And I believe we are ready to go. So, counsel for the appellant, please proceed and enter your appearance.
Good afternoon, Your Honors. My name is Rich Rodriguez, bar registration number 25105, on behalf of the City of Westminster, and I would like to reserve time for rebuttal. May it please the court, the trial court reversibly erred for two reasons. First, the trial court misapplied the law when it admitted a contingent unilateral contract that was too speculative to be considered a reliable property value indicator. Second, the trial court misapplied the law when it admitted certain sales of RDHI's appraiser that were fundamentally different in character than the subject property. The trial court's errors substantially influenced the ascertainment and affected the fairness of the trial. This court should adopt the city's position to ensure a landowner receives exactly what it is entitled to, just compensation, nothing more, nothing less. The court should reject the landowner's position because it leads to speculative compensation and opens the door to the manufacture of evidence, contrary to the rules of evidence and the truth-seeking purpose of trial courts. The court should reverse and remand for a new trial. I want to start with the Erickson agreement, but before I start with the agreement, I want to frame the argument to remind the court what is the purpose of a valuation trial. And the purpose of a valuation trial is for the commission to determine the reasonable market value of the property being acquired as of a particular date of value. And in this case, that date of value is April 30th, 2020. What does reasonable market value mean? Well, the law is clear through a number of cases that means it's the fair, actual, cash market value of the property. It's the price the property could have been sold for on the open market under the usual and ordinary circumstances, where you have a willing buyer, a willing seller, you have an arm's length transaction, and neither party is under any duress or coercion, among other factors. The Erickson agreement and its price does not reflect what the property could have been sold for on April 30, 2020, as if it had been exposed to the market. The sale and the property was never exposed to the market before it went under contract. Instead, the agreement was hastily entered into on the eve of the condemnation valuation trial.
It was entered into April 4th, 2022.
Correct. Yes.
And it was an arm's length, the evidence showed it was an arm's length negotiated contract.
That's what RDHI's position was. We disagreed with that. The problem is the trial court's ruling was entered into about a month before trial, and we didn't have any opportunity to conduct discovery, get any documents from the parties to the transaction, depose anyone. Certainly that was their position, and that was the evidence they introduced trial, that it was arm's length, but we didn't have opportunity.
And the court made a finding it was arm's length.
No, the court did not make a finding it was arm's length. This issue came before the court in limine versus via various motions. And what the court found was the court was going to admit this contract because it didn't find any case in Colorado that expressly prohibited it. And because there was testimony allegedly from the appraisers that said there's a lack of sales in the area, the court said, well, there's this exception of lack of, I'm sorry, that's for the other issue. I apologize. What the court said was that there is no authority in Colorado that explicitly prohibits it. There are some treatises outside of Colorado that seem to allow it, and the court agrees that it would bear on market value.
Mr. Rodriguez, what facts are you relying on to suggest that it was not an arm's length transaction?
The fact that the owner did not produce evidence that it was an arm's length transaction, for number one. At trial, well, none of this, the only thing that was submitted in limine was the contract itself. And then it was just the attorneys arguing about whether it was arm's length and bona fide. And we pointed out all of the reasons why under the agreement it was questionable or suspect. And they obviously argued to the contrary. The court didn't address any of those issues. The court just simply admitted it because it said, well, it's a contract that was entered into on a piece of property that was next to the property you had condemned. So I feel that it's relevant for the fact finder to consider it. So that's what was before the judge when he issued his in limine ruling.
So in your view, who has that burden, the burden to prove that
The owner would have
arm's length?
The owner would have the burden to prove it because they're the proponent of the evidence. And if you look at all the cases that the parties have cited in the briefs on this particular topic, the reality is that in Colorado, there is no case that directly says a sale contract entered into under these circumstances is inadmissible or admissible. There is no case that says that. However, we do have 4 cases where the courts have made very clear that sales contracts are inadmissible. We have the first case was back in 1931, the Colorado Supreme Court in the Loloff case. And in that case, one of the parties was intending to introduce offers to buy the property or a property. And the Supreme Court said, let's look at what the authorities say on this topic. It actually said that they looked
But Loloff was a case involving offers.
Correct.
It was not a case involving an executed contract for sale of the property.
That's correct. It involved an offer. But in this case, that distinction makes no difference because it's our position, and we believe the contract reflects that this quote-unquote executed contract was nothing more than a contingent offer to buy the property, which is in essence the same thing as a mere offer to buy the property.
But counsel, didn't they make a $500,000 deposit? So it was an executed contract. They deposited $500,000 on this contract, and then they started to take steps towards seeking development. That seems like a lot more than just an offer, as in the Loloff case.
Sure, and I'm happy to address that question. It is different than Loloff, but you're getting to a point is where the courts really focus on is what is the true nature of the contract. And in Colorado, if a party enters into a written contract and part of that contract requires them to place a deposit, let's say an earnest money deposit, but there's no obligation for the buyer to buy that property under the contract, which is like the Erickson contract. The Colorado Supreme Court has said that's not a purchase and sale agreement, that's an option agreement. It doesn't matter that the property owner has to forfeit that money. That doesn't convert it into a binding, enforceable bilateral agreement. So that's the situation we have here. Did Erickson pay $500,000 as an earnest money deposit? Yes. Has the seller at this point in time, at the time of trial, and today even, do they have the ability to claim that if Erickson walks away? No, because Erickson extended the agreement and the due diligence period. So if Erickson walks away today, they get that money back. And as far as your question, Your Honor, as to whether they took steps, they haven't taken any steps. They did pay a deposit, but part of the contract requires them to, in good faith, start going through all of these entitlement steps that they said they were going to take to put them in position to close on the property. They haven't done any of it. They had one.
But why doesn't the purchase price that's identified in the contract establish what a willing buyer would pay for this property, for the remainder?
Right, because it establishes only what a willing buyer might pay at some point in the future for this property if conditions A through F are met. That's all that this contract establishes. This contract was not going to close unless and until Erickson obtained all of its entitlements. And that included rezoning, that included replatting, that included an amendment to the comp plan, that included it being satisfied that it was going to have adequate utilities on the property. That included that it being satisfied that the city was going to negotiate access points along Westminster Boulevard. There's a whole laundry list of conditions that the buyer said, look, I'll pay you this money if I get everything I want. And if I don't get everything I want, I can walk away and you can't force me to buy this property, and you can't sue me for damages. If you think about it, Your Honors, what this contract really represents is the other piece of the argument that we're going to get to if we have time, which is it doesn't reflect what a buyer would pay for a vacant piece of land with no entitlements like the subject property. It actually reflects what a buyer might pay if the property were entitled. And that was the crux of the dispute at trial, is our appraiser was arguing this property is vacant land that's not entitled. It's worth $575 a square foot. Their appraisers.
But it was more than vacant land because it had been zoned. It had been platted, right?
No.
But it had been subdivided.
No. Let me correct that. Yet they argue it had been subdivided, and what they're referring to is over 130 years ago, there was this ancient plat that subdivided part of the property into residential lots.
But the plat was still in effect.
But the plat had no value to any purchaser because the appraisers agreed the highest and best use of this property is for mixed use development. And in order to put this property into mixed use development, the buyer would have to replat the property. So the plat that was in place had no effect on Erickson. It would have no effect on any buyer. So that's just a red herring to say that this property is platted. It wasn't platted. And
Counsel, I have a question back on the Erickson agreement. Let's assume for a minute it was an abuse of discretion for the trial court to have allowed the commission to consider that agreement. The ultimate, can you tell me why that wasn't harmless, since the value that the commission determined then was based upon or supported by at least Clayton's appraisal, which was admitted into the record, and which the commission had full, discretion to weigh and consider?
Sure, absolutely. Happy to address that. And just point of clarification, Clayton's appraisal was not in the record. The appraisers testified as to the sales, but nobody's appraisal was in the record. The error here was harmless because what the court is required to look at, and this is the Newsom case from the Colorado Supreme Court 2009, is the proper inquiry is not whether there is sufficient evidence to support the verdict without the improperly admitted evidence. And that's their argument. Their argument is there's other evidence to the record to support the commissioner's verdict. That's not the standard. The Supreme Court said is, does the error substantially influence the verdict or affect the fairness of the trial? And if you go on to read Newsom, the court said, it cited a well-known phrase that's you'll find in a number of cases that says, if a reviewing court can say with fair assurance that in light of the entire record of the trial, the error did not substantially influence the verdict or fairness of the trial, it may be deemed harmless. So that standard you'll see in all the cases. So the Supreme Court explained this is what that means in the next sentence of Usum. It says that means, in other words, a party is entitled to reversal if there is a reasonable probability the trial court's error contributed to the verdict. That's what the Supreme Court said. And it says that this doesn't require that the party who objected show it's more likely than not that the improperly admitted evidence caused the outcome. It only has to show its probability sufficient to undermine confidence in the outcome. That's the standard, and that's the standard we ask you to apply here. And let me give you an example of how that would apply. Let's say in this case there was Erickson was submitting its application to develop, and they called up a witness to say, the planner from the city of Westminster told me that the fee was $300 to apply. Objection, hearsay. And the trial court let it in, and there was an issue on appeal whether that was an error or whether it was a harmless error. In that particular context, and that didn't come up in our case, in that context, it would be harmless error because we're talking about a minuscule piece of evidence that had no relation to the ultimate determination of the fact finder. That's not our fact pattern. Our fact pattern is the trial court admitted a purchase and sale contract entered into on the eve of a condemnation trial without allowing the city to do any rebuttal. And then they emphasized that this is what the commission should find is the value of the property. That's the central issue in a condemnation case. What is the property worth? And so the commission was laser focused because they brought it to their attention. So how they can say that this piece of evidence wasn't relevant because we only spent a few minutes on it just defies logic and the practicality of what the commission was doing. I'd like to reserve the remaining time for rebuttal.
Great. Thank you. I think I neglected to read the name of the case and the case number into the record. We are hearing the arguments in Westminster, the R. Dean Hahn interests, which is case number 2023CA351. I apologize for omitting that previously. Counsel for the appellee, please proceed.
Thank you and good afternoon. I'm Jack Sperber. With me at counsel's table is my colleague Sean Metherow, and in the courtroom is a representative from RDHI, Bill Carney. I want to start by highlighting some of the foundational rules regarding the admissibility of valuation evidence in Colorado eminent domain cases, because I think they explain why the trial court got it right here. Our case law teaches us that because condemnation is a forced taking of property, it's the job of a valuation trial to try to replicate the marketplace and to determine how much a willing buyer would pay to a willing seller for the property at issue in a voluntary transaction. Accordingly, the admissibility of evidence is expansive. It's not restrictive. All evidence tending to bear on the value of the property and all factors that buyers or sellers would consider is generally admissible. The trial court recognized these rules in his omnibus order, and he applied it to the evidence at hand. And with respect to the Erickson agreement, he recognized that while there's no Colorado case directly addressing this issue, that cases around the country and treatises have all looked at contracts on the subject property and have found them to generally be admissible because they bear on the market value of the property. The city, in contrast, is arguing for a new per se rule that contracts are inadmissible as a matter of law, despite acknowledging that Colorado hasn't held that. It turns the ordinary presumptions of admissibility on their head and argues that absent a case expressly holding contracts admissible, they're not. And this is exactly backwards and flies in the face of the foundational rules of evidence the court relied upon. With respect to the use of subdivided sales, the city again advocates for a new rule that's never been recognized in Colorado or anywhere else that I'm aware of, requiring sales properties to have essentially the exact same entitlement and development infrastructure issues in order to be admissible, despite their own appraiser using sales that have all of the same issues that they complain about with respect to the three sales that they're alleging error with. They rely upon the Vail and the Schulhoff case for this proposition, which generally preclude the use of a subdivision development method to value raw land. But neither appraiser used that method here. neither assumed that the property would be divided up into hypothetical lots, added up the value of those lots if they were developed, and then came up with a total value. And the court expressly found that wasn't the methodology being used. Moreover, the RDHI property is subdivided. And yes, it's an old plat, but it's still an effective plat. And the record shows that even in 2012, the city was recognizing the existence of that plat when they were vacating roadways.
Berber, how
Yes.
do you react to your colleagues or your opposing counsel's argument that though it was subdivided, it had no practical value because it wasn't going to be used in the manner indicated in the plat? What's the value of it then if you're going to have to go through a re-subdivision process?
Well, I guess, first of all, I don't know that there's any basis in the law to say that whether it's the subdivision has immediate value presently affects the ability to use subdivided sales to value subdivided land. It's also, I don't think that was the position of the parties in the record. That was certainly the city's position. All parties agreed that this property had a highest and best use for a mixed-use development. There was substantial infrastructure around this property. There were commitments for access. There were commitments for water and sewer. It was not a raw piece of land under any estimation. There's also a body of law that the court recognized that when sales are scarce, when it's difficult to find comparable sales, appraisers are given more leeway in finding the best evidence possible. And the court expressly found in the order that's the subject of this appeal that there was a scarcity of sales. It was very difficult to find properties like this, large pieces of undeveloped land with surrounding infrastructure and development sitting on highway interchanges in the Denver metro area. Most of those things were sold long ago.
Could you address the city's argument that the Erickson agreement was actually an option contract? It was not a purchase and sale agreement because the would-be purchaser needed to accomplish certain things, needed to do certain things before the would-be purchaser was obligated to close on the purchase of the property.
Yes, I think some of your questions are in line with what my answer to that would be, which is it was a bilateral executory contract, meaning that there were terms and conditions that both parties had to complete in order to move forward and consummate a final transaction. And there were contingencies that would allow for its termination. And in that way, I'd suggest it's similar to most sophisticated real estate contracts regarding development land. And as just one example, unlike an option contract where somebody just puts some money down and has the ability to buy the property at a set price sometime into the future, Erickson had both the right and the obligations under this contract to move forward with development applications, to try to get entitlements, to look at development infrastructure. And the money goes hard as it moves along the process. And Erickson is in fact still under contract. It is in fact still moving forward with this. It is involved with the city in trying to advance the development applications. And I would suggest that's going very slow, but it takes very little imagination to understand why the city might be moving slow on that process right now.
Could you respond to the city's argument that the city was not given a full and fair opportunity to explore whether the Erickson contract had been entered into in good faith? And I'm not suggesting that it wasn't.
Right.
But the argument is that the city wasn't able to take discovery on that issue and had to proceed with the trial without being able to test that issue.
Yeah, I think that's simply inconsistent with the record. The record reflects that we disclosed the contract the day that it was executed. That same day, we offered to expedite discovery. We offered to allow for a continuance to allow them to have time to move forward. The city didn't take us up on either of those things. We then ended up with a continuance because of an accident, a bike accident with my colleague, and there was a 7-month delay. During that time period, the city didn't ask to reopen discovery. They didn't push for getting in limine rulings. We had a status conference roughly 30 or 45 days before trial. The court was aware that the motions had still not been ruled upon. He actually chastised the city and said, wait a second, you could have moved forward. You could have asked for discovery during that time period as well, and you didn't. After he ruled on the motions and said the contract was admissible, the order that's in front of you reflects that he would favorably entertain motions for discovery or for a continuance. Again, the city didn't do that. And I would suggest the reason the city didn't do that is that they didn't need to. Erickson was in front of the city's planning department. They were talking to them about moving forward with this application. The city's planning department actually gave information to the city's experts so that they disclosed rebuttal reports immediately before trial. And they actually presented a robust case arguing that this contract wouldn't close because of conditions that would have to be met. So I would suggest they had more than ample opportunity. There were also questions raised both in the briefing and the arguments today about whether this was a real contract and questions about its reliability. To answer one of the questions that you asked earlier, the case law, and again, there's not case law in Colorado on this, but many of the other cases that deal with contracts like this suggest that it is the party opposing it, the party challenging whether it's a reliable contract, has the burden of establishing that. And the city didn't do that. The contract is real. Both parties involved are sophisticated parties. Erickson, the record reflects, was looking to develop this property as part of a $3 billion expansion plan that they were undergoing. They own and operate another facility virtually identical to this in Highlands Ranch that they wanted to develop here. And they have, again, been directly engaged with the city in moving forward with this. So I think it's disingenuous for the city to suggest there's a question about whether this is a real contract, an arm's length transaction between a willing buyer and willing seller. I also would point out that the RDHI was a party to this transaction, right? So one of the things that you see in some of the cases that don't allow the admissibility of contracts, they tend to be contracts on other property. In addition to that being a little more attenuated in terms of its probative value, it's also a little more challenging to get to the evidence, to get to the people, and to test the reliability of the contract. Here, RDHI was a party to the case. It was available for discovery. They were available to testify at trial. We identified the specific individuals in Erickson that were involved in the transaction, and the city chose not to conduct that discovery. They chose not to present testimony challenging that or to call those witnesses to cross-examine them at trial. And I would suggest that tells you all you need to know about whether the contract was real and whether it was reliable. I want to circle back maybe just to one concept about the option contract questions that I don't think I addressed, which is even if you were to agree with the city that because there were rights to terminate this contract, that made it an option contract, I would suggest that's not dispositive. There is no Colorado case that says option contracts are not admissible to prove value. The closest we get to that is the Intermountain case, and that involved an option not on the subject property, but on a comparable property. And the court there did not find error in allowing that option to come into evidence. The city characterized it as finding error, but said that it wasn't prejudicial. But if you read the opinion, and it's a very, very short discussion about two paragraphs, very short paragraphs, the court didn't find any error at all, much less prejudicial error. What the court said was that an expert was allowed to testify about a lease and an option amongst many other transactions, and that was de minimis in the overall face of the evidence that was presented, and found explicitly that the commission did not commit prejudicial error in admitting that. So we don't have any Colorado law that says it's not admissible, and we do have law around the country and treatises. The Nichols on eminent domain treatise that we cited in our briefs explicitly says that executory contracts and option contracts on the subject property, again contrasting that with other properties, is generally admissible to prove value for the obvious reasons that it's probative. I'd like to also address the questions about whether, if there was error, whether it was harmful error. And I'd first like to address the standard of reversal because I disagree with the city's recitation of what that standard is. And I think this is really another example where the city kind of turns the ordinary rules on their head and argues that if it was error to admit the contract or sales, it's presumed to be harmful unless we can prove it's not. But in recent years, the Colorado Supreme Court and this court has repeatedly explained that there is no presumption of harm in most circumstances, including the erroneous introduction of inadmissible evidence. And the Sunahara case that we cited in our materials, Colorado case from 2012, explicitly says that we will only instruct the trial court to order a new trial because of the erroneous admission of evidence where the record affirmatively shows that the error was prejudicial. And numerous courts recognize that if other properly admitted evidence supports the error, the verdict, that any error in admitting other evidence should be disregarded as harmless. And I think the best and most concrete example of just how far the extent of error may go and still be deemed harmless in a condemnation case is the Core Electric v. Frund case. There, the trial court improperly excluded 6 out of 7 sales relied upon by an appraiser. So the appraiser was left with a single sale to support his valuation opinion. And a division of this court said that was sufficient evidence remaining to make the error not harmless. So I would suggest that if knocking out 6 out of 7 sales relied upon by an appraiser is harmless, then surely allowing a contract and 3 sales that were within the range of all other evidence presented is also harmless, particularly when the evidence complained of was actually at the lower end of the value ranges offered. And that's what happened here. You know, the purchase contract suggested a price of $16 a square foot. RDHI's appraiser had comparable sales. And again, he had appraised the property before this contract even came along. And he had comparable sales ranging in price from $10 a square foot to $33 a square foot unadjusted. And then after adjusting for differences, he came up with a range of $17.40 to $25.41 a square foot. And interestingly, 2 of the sales that the city complains about, these supposed subdivision violation sales, were the 2 lowest sales that he used. They were at $10 a square foot and $11.66 a square foot, as I recall. So at the very bottom of his range. And his opinion was actually much higher than the contract price. His opinion was that the portion of the property being taken, which was the highest visibility portion of the property right up next to the highway, was worth between $18 to $22 a square foot, and on a blended basis was at $18.96 a square foot. So if all of the evidence that's complained of was excluded, his values would have actually gone up on an average basis rather than down. And it's also worth noting that the city's appraiser didn't say that the contract, suggested a $16 a square foot value. He argued that if making adjustments for time and other factors, it would suggest a value of $8.44 a square foot. So I would suggest at the end of the day, the commission weighed and balanced all of this evidence and appropriately came on to a value that was not controlled by the contract or the sales. Thank you.
Thank you, Mr. Metherell. Mr. Rodriguez, you have 46 seconds.
Thank you, Your Honors. Back to the Erickson Agreement. The problem when you start relying on other authorities is we each cite authorities that favor both of us, and you can go either way. And the reality is there's no minority rule outside of Colorado. The cases and the authorities they cite that say, other courts let this in, look at the facts of those cases. It was because it was a bilateral enforceable contract that was entered into before condemnation came around, and the government had an opportunity to reject, not our facts. They have to acknowledge Intermountain Terminal. Supreme Court said expressly an optional contract admitting it is error. They don't want to talk about the Hayden case, which is a panel that decided that even a purchase and sale agreement is error. So you're going to have to struggle with that issue and resolve it and get to the issue of whether it's harmless. We ask that you reverse the trial court.
Great. Thank you. Thank you, counsel, for your excellent arguments. And I think I confused Mr. Metherell and Mr. Sperber, so I apologize for that. Your arguments were very helpful for us. So this case will stand submitted, and a written opinion will issue in due course. Counsel for the second case on the docket, People v. Martinez-Rubier, can move forward to counsel table.
Thank you, Your Honor.
It is People v. Martinez-Rubier. I hope I'm pronouncing the gentleman's name correctly. It is case number 2023-CA450. We have experienced counsel who also heard my introductory comments before, so I presume you have no questions, and I think we're ready to proceed then. Counsel for the appellant, please proceed.
Good afternoon, and may it please the court. My name is John Finnegan, bar number 56346, and I represent Mr. Martinez-Rubier. I plan to reserve about 2 to 3 minutes for rebuttal. Mr. Martinez-Rubier presented this court with 2 reasons to vacate the restitution order and 1 reason to reverse it with this case. I plan to focus on the second reason to vacate the award, a lack of sufficient evidence of proximate causation. This court submitted some written questions for the parties to answer. I hope to answer them all during this time, but I'm going to address the third question first, since it goes to the heart of what I'm talking about. And that question was whether the court erred by relying on Progressive's written statement, given that the representative didn't testify and the attorney didn't present, the prosecutor didn't present any evidence at the hearing about how her knowledge that Mr. Martinez-Rubier damaged the vehicle came to be. It's our position that, yes, that is an obvious error by the district court in relying upon that statement. Courts can rely upon written statements in order to order restitution at a restitution hearing, but those statements still have to set out within them sufficient factual allegations to justify awarding restitution, to establish a link, not just of the amount that they're asking for, but approximate causation. And this statement didn't do that, simply asserting that someone owes you money without explaining what that person did, how you know they did it, or even how you know that it's this person, doesn't satisfy the preponderance of the evidence standard. And we know that assertions alone aren't enough because of precedent. Our brief cited multiple cases where the prosecutor asserted and then actually presented more evidence than was at issue here. For instance, in Moss, a motor vehicle theft case, the prosecution said that Moss owed restitution for a new battery and transmission fluid, presented some victim testimony about how that amount was arrived at, but didn't present any evidence about how Moss's actions caused that damage. And the court there found that that wasn't sufficient evidence to order proximate causation. Here we have even less than what we have in Moss. We don't have any testimony or evidence about what exactly Mr. Martinez-Rubier is alleged to have done here. So it's our position that there has to be evidence of his conduct to award restitution based on that conduct. And since there wasn't any here, the court erred in awarding restitution.
Counsel, what do we do with the victim's comp statute, which presumes that the defendant directly caused the damage when it gets a bill asking for compensation? Certainly that presumption can be rebutted, but how does that presumption that the defendant did directly cause the damage play into this?
So I think that actually strengthens our argument for why the evidence that was presented here wasn't enough, because this isn't a victim's comp case where the CVCB is presenting awards that they gave out to the victim. So there is no presumption that Mr. Martinez-Rubier directly caused that result, and therefore it's not his burden to rebut that presumption. It's the prosecution's burden to put on enough evidence in the first place to establish proximate causation.
Mr. Finnegan, I have the sense that you're not challenging the admissibility of the exhibit, the insurance statement.
Right. We're not charging the admissibility. We're just challenging the fact that it doesn't actually say what happened in this case. It just says you owe me money. But
there is some additional information in the exhibit itself that seems to be verifying the circumstances. In other words, it's got the name of the victim, has the name of the defendant, has, I think, a date of the time that the bill was incurred for the towing services, those kinds of things. Isn't that if the exhibit's in, isn't it a fair inference with the name of the defendant, the same name as the victim, same date, and an amount? Isn't that enough to suggest that they have carried their burden?
Well, first, the name of the defendant is actually wrong in that exhibit. It says that his name is Adalberto, parentheses, Aradelio. His name isn't Adalberto, it's just Aradelio. And the birth date is also wrong in that case. It gives him, I believe, a birth date of 1989, and the complaint information says his birth date is actually in 1990. So even on the very minimal evidence that's in there, it itself is internally contradictory based on what the prosecution initially presented, and that I think suggests that it's not enough. But even if we did say, well, we have this name, we have a receipt, we have the victim's name, that still doesn't tell us exactly how or what Mr. Martinez-Rubier did to cause that damage. It's still just an assertion, basically tantamount to complaint information saying you did this, without giving any factual underpinnings as to what exactly he did. And I think that actually goes back to, what is the appropriate standard of review in this case? Because obviously with Martinez v. People, Supreme Court says that usually proximate cause findings are reviewed for clear error, but that's where a person is challenging the interpretation of factual findings by the trial court. And here, there's actually no factual findings that were made by the trial court. So this is still something that should be reviewed de novo, because it is one of those true sufficiency claims that Martinez pointed out should be reviewed de novo, because it's talking about the quantum of evidence that was put on, not the interpretation of that evidence.
I want to make sure we get to the first and third issues. I do want to ask you about an inconsistency in the progressive materials. The document, the cover document called restitution request, says that the above stated amount reflected damages paid to repair our insured's vehicle. Those damages were $1,179. The receipt was not for a repair, it was for towing. Do you think that's a material inconsistency that would be of such significance that we should reverse the court's determination on that basis?
Yes, I think that's an additional inconsistency that this court can look to, is showing that this document within itself isn't anything more than conclusory assertions. The document says our insured's vehicle was damaged for negligence, but then it talks about, or rather the receipt that's given is for towing. And there's no explanation as to how someone's negligence equates to a towing receipt. So it really is just a boilerplate assertion of liability without anything underpinning it. And that's why this court should vacate that award on that basis.
I want to make sure we get to as I said, the first and third arguments. Turning to the first and third questions, the plea agreement contains boilerplate. There's a check mark next to it. The people hereby motion, it should be move, the court to order the defendant to pay restitution with the amount to be determined within 91 days. Why isn't that a request by the people for additional time to submit the restitution information, given that the defendant signed this document the same day as the restitution hearing?
Well, he signed it the same day as the plea hearing.
I'm sorry, the sentencing hearing,
right,
and the plea hearing.
But I think that boilerplate is essentially talking about what the court's burden is under the restitution statute. It's saying we're moving the court to order them to do this within 91 days. It's not saying, like what we saw in Fergosi and in Johnson, two cases where there were waiver found, that the prosecution needs more time to present this information. And it doesn't say that the people need more time to file this report requesting the specific amount. I think you can also look at, there's two options. There's either checking that or checking that the parties stipulate to restitution. So I think all that, the significance of that check mark is that the parties haven't agreed on restitution yet. The people are going to ask for restitution. They might ask for it on the same day as the sentencing hearing, but they haven't said that they don't have the information available to them like they did in, I believe it was Johnson, where they said they'll act in good faith to get this information to the court. I think the court there interpreted that information, or that statement, as indicating that the parties were aware that the prosecution didn't have it at that time. And here, the prosecution makes no representations to the court that they don't have the information. I think the record affirmatively shows that they did have that information. The receipt was emailed to the prosecution's office on July 7th, 2022. I believe slightly more, slightly less than 2 months before the restitution hearing.
Is the mere receipt of the information from Progressive here sufficient for the prosecutor to get up in court and say, this is the amount of requested restitution? Or did the prosecutor need to spend some time to verify the amount and do some additional investigation? In other words, is the receipt of the information from Progressive sufficient without more for the prosecutor to make the restitution request at the time of sentencing?
I think it is under People v. Brazil, which came out recently, holding that the prosecution has a duty to exercise reasonable diligence before the sentencing hearing to get this information before the court so that they can resolve restitution at sentencing. And if the prosecution wants to say, well, we need more time to review this information to affirmatively decide whether we're going to request that, they need to make a record of that. And I think that goes to the second question of whether the court is authorized to extend the deadline without such a record. Our position is that they're not, that shall means shall, and that unless the prosecution tells the court or the parties agree that the prosecution needs more time to request restitution, the prosecution can't just silently take that time without making a record that they don't have the information and they need more time.
Is there any information in the record, one way or the other, showing that the prosecutor did use or did not use reasonable diligence to determine the amount of restitution here?
The record's silent on what the prosecution did in terms of whether they did anything to change or to gather additional information. I think that silence indicates that they didn't use reasonable diligence here because they clearly had the information 2 months before the restitution hearing, and then they made no record at the plea hearing as to why they couldn't present it, and then 10 days later they filed that information apparently without changing anything.
Mr. Finnegan, if we accept your argument that Brazil indicates that this was error for the trial court to extend the 91 days without any finding of exercise of diligence or unavailability of the information, doesn't Brazil work against you on the prejudice end?
I mean, I think it partially it does, because it did find that in that circumstance, the court still had the authority to order restitution. But I do think Brazil is different because it did have the prosecution make a record that they didn't have that information, that they needed more time. And then based upon that, the court was authorized to extend beyond the sentencing hearing to give them that time to file the information.
What's your analytical path to get to prejudice then? How do you get to prejudice if the decision is made within 91 days? We don't have a lack of authority at that point?
Well, I do think there is a lack of authority at that point, because without a record by the prosecution or agreement within the parties, the court can't just unilaterally give them more time, because the statute does say shall present it before sentencing.
So I understand your argument about the wording of the statute, but again, how did that harm your client in that the court did enter the restitution order within the 91 statutory time period?
Well, I do think it actually harmed my client because it deprived my client of being present at the hearing, which sort of bleeds into the third issue. If the prosecution had presented the information at sentencing, then my client could have made a decision at sentencing whether or not to object, and if need be, could have testified at sentencing as to why he didn't do this, which he was completely deprived of being able to do because once they rescheduled the restitution hearing, he was no longer there.
But we don't know why he didn't show up. We don't know why he didn't appear at the first restitution hearing or at the second restitution hearing.
Right.
So going very quickly to that last point, the third point, under your argument, there was no showing that your client waived his right to appear at the restitution hearing. Let's say we reverse remand, there's a new restitution hearing, he doesn't show up again. Why wouldn't there be an endless loop here where he doesn't show up, there's no evidence that he waived his right, and therefore the court would have no choice but to continue the hearing again?
Well, I do think the court can take some steps in the interim to cut off that endless loop. They can, for instance, attempt to serve the defendant with notice that this hearing is taking place. They could actually inquire this time with defense counsel as to whether or not they had contact with their client in the interim, whether their client wants to be present or not. And eventually, at a certain point, I think this court could conclude that repeated failures to appear would constitute a waiver.
At what point would that happen? I know we're coming close to the end of your time, but I'm curious, what if defense counsel keeps saying, we can't reach our client, he hasn't told us he intends to waive? At what point could the court say, enough's enough, he's waived?
I don't have a crisp, cutoff. I think we could probably use the speedy trial statute potentially as a marker. 6 months, I think, would easily be enough to say that that's enough. With that, I will reserve my remaining 13 seconds for rebuttal.
Great. Thank you, Mr. Finnegan. And counsel for the appellee.
Thank you. May it please the court, my name is Brock Swanson, attorney registration number 39116, and I represent the people of the state of Colorado on this matter. I'll start with the defendant's first issue, and our position at this point is that it is resolved by Brazil, that any violation of the prosecution's deadline to disclose restitution information does not deprive the district court of authority to award restitution or require automatic dismissal of the restitution proceedings. Such a sanction would be appropriate, if ever, only if the defendant is prejudiced or the prosecution has demonstrated a persistent disregard for its duties. Otherwise, it would be harmless. And here the record shows that the defendant was not prejudiced. Indeed, it was him who asked much later for a further delay in the proceedings, and that there is no record of any persistent disregard of the prosecution's obligations.
Mr. Swanson, isn't Brazil supportive of the notion that there needs to be a greater effort by prosecution to get this information at the time of sentencing? Because that's what the General Assembly has mandated. But as it relates specifically to the prejudice argument here, I hear Mr. Finnegan to be arguing that, look, if that had happened in this case, he was present, and he would have been able to provide information contesting the amount. So how do you address the prejudice argument?
Sure. Sorry.
Go ahead.
So, I mean, my first response to that would be that some 3 months later, when they arrived at the first restitution hearing, one of the issues was that the defendant was not present, but the other was that defense counsel represented they not yet completed discovery regarding the issue. And so I think the prejudice, the theory there would be presuming that if the prosecution had filed this at sentencing, their request, I don't think it's realistic or even reasonably probable that they would have been able to have the hearing at that point, because the request would have just been filed then, and there's not necessarily any disclosure of information. And even after that 3-month period, it had shown that the defense counsel had not yet completed that process and needed more time to investigate whether that request was reasonable.
Can we
Sure.
Can we presume, based on the date on which Progressive emailed the restitution information to the district attorney's office, that the prosecutor did not use reasonable diligence to come up with the restitution figure by the time of the sentencing hearing?
I would say no, and I'd say no for a couple of reasons. But the biggest reason is just we just don't have any information about this because it wasn't inquired into in the district court. And that is, I think, a standalone reason for not addressing this issue. Because when Fransua says that you can address these illegal manner claims for the first time in appeal, it says if the record is sufficiently developed to be able to address them. In Brazil, there was a record developed, and so it was able to address whether the prosecution had made diligent efforts. But if there's no record developed, the defendant doesn't object, or the trial court does not require some record to be presented there, then we just don't have the record to be able to make that determination. I'll also note, this was a case that arose out of a different county. I don't know whether it was a different prosecutor. I think it is the same prosecuting office, but not necessarily the same prosecutor. It's a plea bargain that came into. I don't know when exactly they made this agreement. If the
Well, counsel, I was going to ask a
Sure.
question about that, because there's a motion in the record from defense counsel to change the preliminary hearing to a dispositional hearing that was filed a month before, a little less than a month, August 24th, and the actual plea and sentencing hearing was on September 20th. So if a month before the prosecutor had this invoice from Progressive, and then the next month they knew, okay, well, obviously the parties had reached a disposition and there was going to be another 3+ weeks before they had to do this. Isn't that additional evidence that reasonable diligence wasn't used?
I mean, I don't know. I don't know what the facts are here. I don't know what happened or what the prosecution did. I will also note that, at the restitution hearing that was eventually held, the prosecution represented that it had repeatedly tried to contact the insurance company here and in their effort to get them to appear, and they just had not been able to get a response from them. So I think that could potentially, but this is just speculation. I don't know what happened because we don't have a record about that as to what they did. And this was also, I will note, prior to Brazil coming out. So I don't think that generally the prosecution had an understanding that it had to make these reasonable efforts, and I think they had a reasonable position that they didn't have to. Obviously, Brazil rejects that argument, and going forward, we have tried our best to make sure that all the prosecutors know that is a requirement now. But at the time, they didn't necessarily have that information, and I think that leads into the prejudice argument in that they given that they didn't have this notice, it would not be appropriate to impose this kind of draconian penalty of there's no restitution awarded here now, when they were acting in good faith as they understood their legal obligations at the time.
I'd like to turn to the language of the plea agreement. As I noted in my question to counsel for the appellant, that language says the people hereby motion, again it should be move, the court to order the defendant to pay restitution with the amount to be determined within 91 days. Where in this language is there a request to the court that the prosecutor be granted more time past the date of the sentencing hearing to provide the restitution information? There's no reference to the information not being available.
Yeah. So I think your question to my opposing counsel here kind of presaged our argument, which would be that this happened at the combined Providency and immediate sentencing hearing. And that reading this language, which says that the people will file a report requesting the specific amount, and that the amount of restitution will be reserved. Reading that in context, that indicates an understanding that the prosecution doesn't have the request right now and will be filing it in the future. And I think that reasonable reading is confirmed by the conduct of the parties, where the district court, without any further discussion, set a deadline, set up a scheduling order to address when this restitution request would be due, and also by the conduct of the defendant in not objecting and complying with that order and going forward with the proceeding without ever in the district court raising any complaints suggesting that the prosecution had in any way failed its duties with regard to disclosure here, or that had been in any way prejudiced by the proceedings that had happened.
Would you agree that the district court lacks the authority to grant the prosecutor an extension of time past the date of the sentencing hearing to provide the restitution information unless, one, the prosecutor asks for additional time, and two, in that request, the prosecutor represents that the restitution information is not available prior to the sentencing hearing?
Our answer to that would be no. And the first reason I think that is because that is not in the statute. There's no requirement in the statute for express representation or for an express finding by the court on that issue. And I don't think it needs to be added in here. I think the district court can generally infer from the mere fact that the prosecution has showed up at sentencing and hasn't presented their request, they don't have one ready. If they had the request already prepared, they would have presented it.
I'd like to push back on that a bit.
Sure.
So the first clause is, the prosecuting attorney shall present this information to the court prior to the order of conviction. That's the first clause.
Mm-hmm.
Or within 91 days if it is not available prior to the order of conviction.
Right.
So the court's not going to know if the prosecutor does have the information or doesn't have the information. Only the prosecutor can advise the court whether the restitution information is not available at that time.
I would say the statute doesn't say anything about the district court being involved in that process at all. It doesn't say the court has to grant them additional time, that it has to make any kind of finding. The prosecution, if it does have the information available, should present it. If it doesn't, it has an additional 91 days. I don't think there's any court involvement at all that's required by
But in the
statute.
next sentence, the court may extend this date if it finds there are extenuating circumstances. And there are two dates in the preceding sentence. One is prior to the order of conviction, and the other is within 91 days if the restitution information is not available at the time of the order of conviction.
And in Weeks, the court expressly addressed that provision and said that that provision only applies to an extension beyond 91 days. That the court does, that the prosecution does not have to make any extenuating circumstances showing in order to extend the deadline up to 91 days. It's only that.
It seems that you're saying that the language that the prosecuting attorney shall present this information to the court prior to the order of conviction, with all due respect, to me, you're writing that language out of the statute. Because if there's no need for a court order to extend the deadline past that date, what prosecutor wouldn't simply provide the information within the 91 days?
Well, there can always be an objection by the defendant, an assertion that they've not made this. And then at that point, the court would address that, and we'd have a record to say whether or not the prosecution has done this. I also think the prosecution will reasonably and in the ordinary course follow its duties as they are laid out by this court in the statute.
Two things. It hasn't historically. That's the whole point of the Weeks decision, and it being the prosecution hasn't followed it historically, number one. Number two, I understand your statutory argument, but isn't that statutory argument foreclosed by Brazil?
I don't think so. I don't think that statutory argument is foreclosed by Brazil in the sense that that I don't think it requires an express finding by the court as to that if the issue isn't raised.
I heard you, though, transposing or suggesting that this was something that the prosecution should do. The statute, as Judge Lipinski pointed out, says it's something that the prosecution shall do at the time of sentencing. And I think Brazil amplified that and said, again, you have to exercise or show that you have exercised reasonable diligence in order to get the extension.
I guess it's that second part that I would push back on. They are, under Brazil, required to recognize that reasonable diligence. I'm pushing back on whether they have an affirmative duty to establish that at sentencing if the issue is not contested.
Can we ask you to jump to the third issue, if you would?
Sure, yes. And by third issue, do you mean the presence or the third question? Okay.
Please.
Sure. Okay. Regarding the right to be present, defense counsel cannot waive a defendant's right to be present at a restitution hearing on their behalf, but they can convey to the court the defendant's waiver. In other words, the defendant doesn't have to be present to waive their presence. And waivers can be conveyed implicitly. They do not have to be expressed. Here the record shows that defense counsel conveyed to the district court through their actions that the defendant had waived his right to be present. And we additionally
but there was no indication at the second hearing that defense counsel had been able to contact Mr. Martinez-Rubier, had told him the date of the hearing, and there's no evidence, no indication in the record that defense counsel had told Mr. Martinez-Rubier that if he didn't show up, there might be a waiver.
Yes, there's no express language to that effect. It wasn't inquired into, and I'm not going to argue that that was best practice to not inquire into that issue. But I think to assume that that didn't happen would be to presume that defense counsel provided deficient performance. And that's something we can't do on direct appeal.
It may be that we can presume that defense counsel tried to reach Mr. Martinez-Rubier and couldn't reach him. We just don't know either way.
Well, if defense counsel had tried to reach them and couldn't reach them and then showed up, he should have said, we need to have another continuance. I couldn't reach the defense counsel, or I couldn't reach the defendant, and he has a right to be present and hasn't waived it.
I don't see how we can make that assumption given the record here.
We're making that assumption based on the presumption that defense counsel provided effective assistance that we have at this point, at this stage in the proceedings, because this is a direct appeal. And that where the hearing is continued so that defense counsel can obtain a waiver from the defendant and then appears at the continued hearing without the defendant and proceeds with the hearing, it shows that defense counsel obtained the waiver. So that's the argument. If this court disagrees and concludes that a more express discussion is required, then the case should be remanded for that purpose. And before vacating the restitution order, there should be a proceeding to find out more information about whether that waiver occurred.
Under what case authority can we make the presumptions that you're suggesting that we make?
The presumptions that the defense counsel
That
provided
confident-
deficient performance, or
And
provided effective
in
performance.
doing so,
Yeah.
had some communication with Mr. Martinez-Rubier, and that if defense counsel had not been able to speak with him, defense counsel would have told the court, we can't proceed with the hearing today.
Yeah. So for the first part is just a general principle. I think I've cited some cases. The second part, I don't have any direct authority on that point. I'm arguing that it derives from the principles that we otherwise have. I see I don't have much time left. If the court has any other question, I'd be happy to answer it on the other issue or anything else. Otherwise, we'd ask that this court affirm. Thank you.
Thank you, Mr. Swanson. Mr. Finnegan, you have all of 12 seconds.
Just with regard to the third issue and defense counsel's need to request a continuance, the court had told defense counsel at the hearing immediately prior, I'm having this hearing whether your client is here or not. Tell him if you can get in touch with him. So if defense counsel had made that record, there would have been no point in doing so. The court had already made clear that they were going to go forward with the hearing regardless of the defendant's presence. We'd ask this court to vacate the restitution award.
Thank you, Mr. Finnegan. Thank you to both of you for your helpful arguments. The case will stand submitted and a written opinion will issue in due course. So we'll give you a minute to pack up before we call the third case. Is Carranza v. Lafayette. It is two consolidated cases, 23CA1398 and 23CA1755. I don't think all counsel were here when I gave the preliminary instructions at 1:30. First, does counsel have any questions about our procedures? Seeing no questions, as you know, the appellant does have the ability to reserve time for rebuttal. You'll need to keep an eye on the clock. We're not going to keep track of your time for you. If you run out of rebuttal time, you've run out of rebuttal time. And let's see, in this case, I don't believe we need to refer to anyone by initials. There are no crime victims. Well, there is a potential crime victim, but I don't think we need to refer to him by initials. There are no juveniles. I would request that you turn off your electronics so they don't interfere with the court's video recording system. That covers the preliminaries, so let's proceed. Counsel for the appellant.
Thank you, Your Honor. It may please the court. I am Joe Pickard of Pickard Law, attorney registration 12476, representing Olivia Carranza, the plaintiff and appellant, and the widowed spouse of Ricardo Medina Rojas. With me are Esteban Martinez of Martinez Law and James West of his office also. We are appealing the summary judgment order issued June 27th, 2023. It's in the record at 988. The court made two legal conclusions, at least two, that we believe are erroneous. This is the basis for the appeal. First, that pertaining to the workers' comp exclusivity or bar, and second, with respect to whether or not the SAL defendants were a statutory employer, such that they could be eligible for the exclusivity of the workers' comp. On the first issue, the trial was incorrect when it found that no tort claim could be brought because of the receipt of workers' comp benefits. First, the court made a mistake and thought that we had proceeded to apply for and obtain workers' comp benefits first and then brought a tort claim. In fact, the reverse is factually what happened. And we'll talk about whether that makes any difference or not probably as we go forward, and I'm not sure that it does. But what it did is give sort of insight when you look at her order, which was entered, as I said, and it's found in the record, that it was because workers' comp benefits were received that there could be no tort claim, and she refused to apply the Horodisky analysis to determine whether or not there was some claim that was outside of workers' comp coverage. So she never got that far. And that's exactly what the court said in its order, was that this was the specific ground for doing that. The court also said that there were no cases cited by the plaintiff, but I assume that the court meant that of which the court was aware, where there was first a workers' comp benefit paid and then a tort claim brought. Well, in fact, there are several, and they're in the briefing this before the court. But at the time before the trial court hadn't made it known that that was going to be the basis for decision. But one of the cases had already been cited in a couple of ways to her, and that was the Popovich case. In the Popovich case, the plaintiff in that case had received $3,138 in workers' comp benefits before she brought her tort claims, and she settled the rest of her workers' comp claim at that time. The fact that that had occurred in the Popovich case was also discussed explicitly in the Horodisky case. So anybody that looked at Horodisky or the Popovich case, anyone that read that, would know that those were the facts of that case. It just wasn't the point at the time. We thought there were other reasons why the court should rule against the summary judgment.
Mr. Pickard, would you agree that that the question of whether or not there is a statutory bar depends upon whether or not the defendants, one group of defendants or the other, or both, can be characterized as third parties?
I think that has something to do with it, and that's the second point. I'm going to talk about that in just a minute. If you want me to go into it now, I will.
It's up to you.
I'll get to it, I promise. Okay. But yes, I think it makes a big difference, because if someone is a third party, then there's just no bar. Because the statute itself provides for bringing claims against someone who is not in the same employ, and then provides for a lien or subrogation rights in the statute. And that's something we argued throughout, was if there ever should be any issue about double recovery, that there should be an offset for anything that was recovered twice. And that's mentioned in Popovich, and it's mentioned in much more detail in Ferris. Ferris is a case that's it's in the briefs on both sides, but really not analyzed by the defendants, other than a statement that it doesn't apply. There's really not much analysis there. But at the very end of Ferris, there is a long description about, it was posited in that case as a election of remedies kind of situation. And so wasn't it already barred by the fact that you elected in Ferris to receive a $45,000 workers' comp settlement? And they analyze why that's not the case at the end of Ferris, and say that there is to be no double recovery, though. If it's for the same damages, there'll be an offset. So that's described in those two cases. In both of those cases, it's workers' comp first and then a tort claim. In a case cited by the defendants called Varsity Amusement Company, there was first a tort claim, which was settled, and then a workers' comp claim was made. And not surprisingly, in the workers' comp claim, the defendants in that case argued, this is res judicata. It's already been decided. You can't bring a workers' comp claim on the same injuries arising out of the same incident if you've already received a tort settlement. And the decision that was overturned. And so we have 3 cases, 2 of which where there was a workers' comp claim first, and 1 in which it was a tort claim first. But in none of those cases was it the determination of any court that workers' comp is mutually exclusive with tort damages.
I want to ask you a question regarding the content, the substance of the trial court's order. Trial court or district court's order refers to employer in fact and references the Lafayette defendants as the employer in fact. Do you take that to be the equivalent of, let's use the word traditional employer, as opposed to a statutory employer? Is that what you understood the finding to be?
That's what I understood when the court did that. And that's, so I'll turn to the other point now. And the court said that was the employer because, well, that's what we alleged. And the other side really didn't, the defendants didn't really deny that. They just tried to align the SAL defendants under the Lafayette defendants so that there would be this stream under which they would claim that there's a statutory employer relationship. But the evidence before the court, and this is at page 8, I have it at 682 of the record, was there a management agreement. And the management agreement was between Lafayette, or the operator, if you will, and SAL management defendants that were the managers, supposedly managers. And in that contract, it specifically stated, it was an interesting, all-encompassing kind of provision about employees, and it stated that all employees at the facility would be employees of SAL management, and that none of the employees at the facility would be an employee for any purpose of Lafayette.
Is it your argument that a worker cannot have both a traditional employer and a statutory employer? That it has to be one or the other?
No, I think you can have a traditional employer and a statutory employer.
For the same worker?
Well, I think they owe their original duty. I think you can argue about whether, as a matter of law, it's a statutory employer. But their duty, the employer-employee relationship, is between them and their employer.
So could you point to the record information showing what relationship Mr. Medina Rojas had to the SAL defendants? Is there anything in the record to show someone from SAL supervised him, controlled his work, that he reported to anyone from SAL, that SAL paid him? What in the record shows the nature of that relationship?
Yeah. And we didn't find much, and we briefed that issue. You'll see our references in the brief that we couldn't find it. There were things we didn't see. We don't know who his supervisor was or how that worked. But to finish what I was talking about, Mr. Medina Rojas was paid by Lafayette, not by SAL management defendants.
So let me just interject. I want to make sure I understand this, Mr. Pickard. You're not arguing by virtue of the contract provision that the trial court erred in finding he was the employer in fact. You're just saying that he was, despite what the contract says, he was the employer in fact, or the traditional employee in fact, or traditional employee of Lafayette, and you're not contesting that.
As far as what you just said, Your Honor, yes, that's exactly what we're saying. The difference, why is it important? Because of the original question you asked me, that would make someone who's not in the stream between the employer and the employee, someone collateral, that would be a third party. That's SAL management. If they are not the statutory employer. And our argument is that when you look at the record was presented to the court for summary judgment, the primary evidence before the court was the management agreement, which states in it specifically that he's not to be an employee for any purpose for the person that turned out to be his employer, Lafayette. And therefore, if you want to say, and this is where things get, it's where the law gets thick, I think. When all the cases talk about the downstream thing, and it doesn't matter how many subcontractors you have, you're all statutory employers. Well, or that you are an agent of the operator. There has to be an issue about what's the purpose and scope of your agency. But when you drill down to it, you find out that the only agreement between the two of them, and the very agreement that the court used to make its determinations, was contradicted by their practice, then I think that calls into a fact question about who really was the employer and under what circumstances, and whether or not SAL can then claim statutory employer status. And that wasn't done in the trial court.
I took from your briefing that you weren't contesting that conclusion factually, that Lafayette is the traditional employer.
We're not.
Okay.
Because that's who we thought. I mean, that's who paid him, and that's who we made the application for workers' comp benefits against.
But back to your argument about the inconsistency between the management agreement, if you're not contesting that issue, we don't need to get bogged down with it, right?
Well, not on that part. I think those facts are set, and I think that is who his employer was. But we do dispute who his statutory employer was. But yeah, I think he worked for somebody. I think that's who it was. So I talked about Ferris, again, which I think is, there's a lot of claims brought in Ferris, so there's a lot in that case. But at the very end, there is a whole section on what's called election of remedies. Very important. And all of the cases, including the Varsity Amusement Company case, all three of these, where there was both a tort claim and a workers' comp claim, the court had the opportunity to say, it's either one or the other, like our trial court did. But none of them did that. And in fact, Horodisky doesn't do that either. Horodisky, it's really not exactly stated in the Horodisky case whether or not there was ever a workers' comp claim. It doesn't say. I'm going to assume, for the sake of argument, there wasn't one. But when the Horodisky case was analyzed, what they said wasn't that workers' comp or tort are the only two options. What the Horodisky court said was that where you have a claim that is not covered by workers' comp, that you can proceed in tort.
Can I ask you to shift gears and talk to us, you don't have much time left, but talk to us about what factual issues you think establish that this was a private assault, or what facts do you think were material to that resolution that were disputed between the parties?
First, I'd rely on every allegation we made in the Second Amended complaint, which
that doesn't help us.
I will get more specific. Yeah. I don't want to leave anything out. That's all by saying some part of that. And next, I would start with the definition of what arises out of employment. And this is Horodisky, and it's, quote, has its origin in an employee's work-related functions and is sufficiently related to those functions to be considered part of the employee's employment contract. So this is what you were hired to do, and that's what you're expected to do, and that's part of your job. So that's where I'd start. In this case, the shooter was a 95-year-old resident of the defendants and at that facility. The staff there knew, as part of the OSHA investigation and police reports that were exchanged, they knew that he carried a handgun around in a bag attached to his walker. They knew that. They also knew that he had a rifle at different times. He had a different handgun in his room at different times. At some points, they took guns away from him, and then they found guns with him again later.
But Mr. Pickard, that really is your negligence claim. What is it? What are the facts you're relying on to suggest this was a private assault under the Rorschach analysis?
With those facts and the others, including that he specifically targeted Mr. Medina Rojas to kill him, with those facts, that supports our outrageous conduct claim, which is
But Mr. Medina Rojas was targeted because he was an employee at Legacy. The shooter, Mr. Payne, thought that the employees at Legacy were stealing from him. He had these conspiratorial ideas. This was not a separate beef between the two of them, unrelated to Mr. Martinez Rojas's or Mr. Medina Rojas's work at Legacy.
I disagree, Your Honor. He said specifically he was going to kill Mr. Medina Rojas and or one other employee. It was not the next time I see anybody, I'm going to kill him.
But
And
didn't Mr. Medina Rojas, he had access to the shooter's room. And that's what the basis for the whole conspiracy. That's why his paranoia, that's why he thought people were stealing from him and putting cameras and spying on him. That was Mr. Medina Rojas's job, was to go into people's apartments and resolve maintenance issues, right?
Right. That was the basis for him being there. But just being there doesn't give someone the right to commit this kind of an action against you. Horodisky determined that for us. All of that took place on the job. All of it in Horodisky. And that's the case we're bringing this case under.
All right, thank you, Mr. Pickard.
Thank you very much.
Please add 48 seconds to the appellee's time. We'll take a moment to get the clock reset. And counsel for the appellees, I should say.
Thank you, Your Honor. Jared Ellis, registration number 36834. I am appearing today on behalf of the SAL defendants. I have agreed to split time with my co-counsel who represents Lafayette, and I'm planning to take the first 8 minutes of argument, and he'll take the remaining time. Plaintiff is basically asking this court to ignore the plain language of the Workers' Compensation Act. She's asking this court to hold that she's entitled to a jury trial regarding whether the Workers' Compensation Act bars her claims, even though she applied for and accepted workers' compensation benefits, even though she admitted she could only receive those benefits if the statutory requirements of the Workers' Compensation Act, including the requirement that the injury arise out of the employment, was satisfied, and she submitted no evidence demonstrating that questions of fact existed in response to the motion for summary judgment. This court should affirm the district court's judgment because plaintiff failed to carry her burden of demonstrating that questions of material fact existed. And based upon the record before the court correctly determined that the plaintiff's own admissions established that the Workers' Compensation Act barred her claims as a matter of law.
But doesn't the bar only apply if your clients are covered by the act? In other words, that they're either the traditional employer or the statutory employer.
And I think that there's one other category of entities that falls
Agents.
under that. But I agree that, yes, the Workers' Compensation Act bars claims as to employers, agents, and statutory employers.
Okay.
Can you respond to the appellant's argument that the management agreement, or that the parties didn't follow the terms of the management agreement, that the management agreement says that Mr. Medina Rojas was not an employee of Lafayette, which was not the case, and that the contradiction, if you will, which is, I believe, the term that counsel for the appellant used, raises factual questions that precluded or should have precluded the entry of summary judgment in your client's favor?
Yes, I can respond to that. I don't agree, and there are a few reasons for that. But primarily, I think the easiest way for this court to address this issue is based on the issue of agency, because it's clear in the law that an employer's agent is entitled to immunity under the Workers' Compensation Act. And in this case, the SAL defendant submitted 2 clear and unequivocal pieces of evidence that an agency relationship existed. First, they submitted an affidavit from Scott Monson, an owner of SAL Management Group, who stated that SAL defendants were agents of Lafayette. They also introduced admissions by Lafayette that the SAL defendants were its agents. So you have both agent and principal admitting that an agency relationship existed.
But counsel, doesn't the agent's provision presuppose that there is a statutory employer relationship?
I don't believe so.
Can you point me to a section that talks about the agent exception applying to the traditional employment relationship as opposed to a statutory employer relationship?
I can't off the top of my head, but I believe we've cited to a statute in our briefing that indicates, and a case in our briefing, that indicates an employer's agent is covered by that provision. I'll see if I can find the case quickly here. Give me just a moment. So there are a few cases that support this proposition and a statutory section. So CRS 841-401-2 And then the Halter and Waco Scaffolding and Equipment Company case, which is 797 P. Second 790 at 797.
But both of those cases were statutory employer cases, right? And the statute there is
I don't believe so. I think the Halter case was an agent of the actual employer.
but where the party who's claiming the immunity was a statutory employer.
And an actual employer, an employer in fact. In the Halter case, my recollection is that it involved an architect who had been hired by the claimant's employer, and there was a claim of negligence against the architect, and that the court in that case decided that the architect was entitled to immunity.
So you're arguing that your clients, the SAL defendants, were not the statutory employer or employers of Mr. Medina Rojas?
No. My argument is the easiest way for the court to resolve this issue is just on pure agency grounds. But we also believe that the evidence established that we were statutory employers. And there's a couple of key reasons for that. But primarily, the employment or the relationship in this case is typical of what's described in the statutory employer context, which is there's a contractual relationship between an employer and a subcontractor, in this case, the SAL defendants. The SAL defendants, as a part of that contract, were responsible for managing the facility. And one of their contractual obligations was that if the employer failed to provide them, they were required to provide benefits for all of the facility employees. And case law in Colorado is clear that as long as you're liable for paying benefits, you're entitled to immunity. So
Does the record show who paid the benefits to Mr. Medina Rojas?
sure, it shows that Lafayette paid the benefits, but keep in mind, statutory employers in fact, are all entitled to immunity regardless of which one of them pays the benefits. And the reason for this is pretty obvious. You often have businesses that are operating through various entities. The objective of the statute is to make sure that employees receive compensation. One of those entities is paying for the benefits. And if none of the entities pay for the benefits, none of them are entitled to immunity. So the way that the statute works is by encouraging the various entities that are involved in operating a business to make sure that there's coverage available for the business's employees so that all of them can enjoy immunity. And that's what happened in this case. I'd like to turn very briefly to the issue of why the Workers' Compensation Act bars claims in this case. I think you heard plaintiffs' counsel mention that there are cases in which plaintiffs have received money, workers' compensation benefits, and still been permitted to bring claims. We think that those cases are both procedurally and factually distinguishable, primarily because they arise in a completely different context that involves claims of workplace sexual harassment by co-employees. That's obviously not the context that we have here. But the important thing to keep in mind is that the court determined in this case that the plaintiff had admitted that the requirements for the Workers' Compensation Act to apply have been satisfied by applying for and accepting benefits.
Is it your argument that Ms. Carranza could not bring claims against Mr. Payne?
Absolutely not. She can bring claims against Mr. Payne. He's a third party. And so looking at the record, the court relied on an admission by the plaintiff that workers' compensation benefits could only be paid if statutory requirements were satisfied, including the requirement that the injury arose out of or in the course of the employee's employment. That was at page 911 of the record. And then there was evidence, including plaintiff's notice of claim that was filed with the in support of her workers' compensation claim, and that was signed under penalty of perjury, stating that the basis of her claim was her husband's death after reporting to work as a maintenance worker.
Isn't this the same argument, though, as the one that your clients, the SAL defendants, were agents of Lafayette, and therefore were agents of the traditional employer, and therefore the workers' comp bar protects them, or alternatively, they were statutory employers and they were protected as statutory employers?
I think it's two separate issues. So one is, assuming that we are a statutory employer or an agent, then the Workers' Compensation Act applies. But as I understand it, plaintiff is arguing that they're entitled to a jury trial, even if that's true, because they can accept benefits under the Workers' Compensation Act and still get a jury trial on whether or not that act bars their claims. We think that that's wrong. We think that the court addressed it correctly by distinguishing the Huradeski case and saying that case didn't involve a case in which a plaintiff had admitted by receiving benefits that the requirements of the statute were satisfied.
Mr. Ellis, did your client, did the SAL defendants carry workers' comp insurance?
It's not in the record, Your Honor.
It is or is not in the record?
It is not in the record.
And do you have any information on that?
I don't in front of me right now, but again, I don't think it matters as long as one of the people that are involved in that statutory employment or employment relationship does. All of the statutory employers and employers are entitled to immunity. And with that, I'm going to ask that the court affirm and turn things over to my co-counsel.
Good afternoon, Your Honors. May it please the court, my name is Chris Soper, registration number 50470 from Taylor Anderson, and I represent the Lafayette defendants, which is the traditional employer we've been talking about. I'll be addressing 4 different issues. The first is whether Mr. Medina Rojas was performing a task that arose out of and in the course of his employment. The second issue I'll be addressing is whether the 2 individuals had an inherently private dispute. The third issue is whether the awarding of costs was within the discretion of the trial judge. And the fourth is whether appellees are entitled to attorney's fees for going through this appeal. Regarding the first issue, Mr. Medina Rojas was employed as the head of maintenance for the Winnetka Park Assisted Living Residence. His job was to maintain the entire building. He literally was a jack of all trades. He did plumbing, he did electrical, he changed light bulbs, he fixed the fire alarms. If a resident needed a picture hung, he would go in the room and he would hang a picture. In order to do all the maintenance around the building, a necessary and essential part of his job was to walk from one place to another. At the time that Mr. Medina Rojas was shot, it's undisputed that he was on the clock, he was being paid for his time, and he was in the lobby of the building that he was physically employed to maintain. In appellant's own words, quote, Mr. Medina Rojas reported to work as a maintenance worker when a resident of Lafayette Leasing LLC, Okie Payne, shot Mr. Medina Rojas in the head, killing him. That was, quote, directly from her submission for workers' compensation benefits, which my client did not deny. They accepted. What appellant does dispute in their briefs is that Mr. Medina Rojas was performing a task related to his employment at the time he was shot. They claim he was just walking. It's not his job to dodge bullets. They seem to think that because he didn't have a light bulb in his hand or he wasn't sweeping a broom, that he wasn't performing a maintenance task. But at the time he was shot, he was walking from a location in the building where he'd done safety checks, through the lobby, walking to the place where he was going to next perform maintenance. That walk from one place to another is just as much a part of his job as screwing in a light bulb or sweeping the floor. And this, frankly, Your Honors, walking from place to place as part of your job is something that's true for every employee that works outside your home. As a matter of fact, I bet Your Honors had to walk from your chambers down a hallway to get up to the bench that you're sitting on right now. If you had tripped and fallen while you were walking, are you not covered by workers' compensation benefits because walking isn't reading a brief or conducting oral argument? Of course not. That's not the law. All right, moving on to my second point. Did Mr. Payne and Mr. Medina Rojas have an inherently private dispute? And Your Honors asked a very pointed question. What facts in the record support that these 2 men had a private relationship? And you got no facts from the record in response, just that Mr. Medina Rojas was specifically targeted. That's it. These 2 men had no relationship out of work. They didn't socialize outside of work. They didn't have phone calls. They didn't have exchange text messages. And they certainly never had any sort of romantic or sexual relationship, which is what has historically justified a finding of an inherently private dispute. For example, in the Hora-Diskish case versus Karanian, an opinion that appellant relies heavily upon, that case related to a workplace sexual harassment claim. Again, inherently private, relates to sex and romance. Those are things that are inherently private.
Also, who has the burden of showing the factors or establishing the factors to establish that it is a private versus neutral versus arising, out of the traditional employment relationship? Whose burden is it to show that the facts are undisputed on that issue?
I don't mean to shoot off the hip, Your Honor. I don't have a cite or a case for that authority. My presumption is generally how the law works is that if someone's claiming an exclusion, it's the person claiming the exclusion that has the burden of proving that that exclusion applies. So I would think, without being able to cite any cases here at the lectern, that it would have been appellant's duty to prove that this exclusion does apply.
And what facts do you think establish as a matter of undisputed fact, and therefore a matter of law, that that this relation, or this assault did not arise out of a private relationship.
And I can cite you to a case for that this court's own opinion in re Def of McLaughlin is directly on point here. And I think what nobody's really addressed here is what this case actually is. This is a case where you have an intentional assault by a delusional assailant. And this court addressed the issue directly in re Def of McLaughlin. And in that case, a deceased worker's family was entitled to workers' compensation benefits after he was shot by the jealous husband of a coworker. And it's very similar to this case. This woman's husband had delusions thinking he was having an affair or something with his wife. It wasn't true. He was delusional about it. He was wrong. It didn't stop him from shooting this person. And in that case, it's also like this case because the husband actually threatened to kill that worker for 6 months. He threatened to kill that worker at lunch that very day and then went and shot him. And this court still found that that person that had been shot was entitled to workers' compensation benefits under the facts of that case. And that's almost the exact same fact pattern as what happened with Okie Payne. He was delusional. You know, the reason that Okie Payne shot Mr. Medina Rojas is because he had these delusions that Mr. Medina Rojas, who had access to his room, was setting up cameras and listening devices and was spying on him and stealing money from him. That's why he got shot. It was based on these delusional beliefs, all related to their interaction with each other at Winnetka Park, nothing outside of Winnetka Park. Moving on to my third point, Your Honors, is related to the awarding of costs, which wasn't even addressed in the appellant's oral argument, but they did file an appeal related to this. The trial court was provided Dr. Smith's 21-page single-space excerpt report, a vast list of documents he reviewed in preparing that report, his invoice, his hourly rate, and by deduction of the hourly rate and the invoice, that he spent a total of 18 hours working to do all of that. This information was more than sufficient for the trial judge to determine Dr. Smith's fees were reasonable, and I would like to add that defendants split the cost of that one single expert again to keep costs down, to be incredibly reasonable. A very modest request for fees in this case that was reasonably granted by the trial court. And my final point, Your Honors, relates to the entitlement to attorney's fees. There's simply no substantial justification for the appellant to have included the traditional employer in this appeal. It blew my mind when I heard that. The first thing they said is, we're not contesting the traditional employer in this case. I said, well, why have I briefed all these issues? Why have I come to oral argument when you're basically saying today that I shouldn't even be here?
But the appellant's saying you should be here because the shooting was part of a private dispute. And if they prevail on that point, they prevail against your clients, right?
If they can prove that it was a private dispute, yes. But that issue's already been resolved by this appellate court in Ray McLaughlin, and there's no other conflicting authority on that point.
But the three of us haven't resolved it in this case yet.
That's correct, Your
So
Honor.
I see the red light's on.
Yes, apologize, Your Honor.
Thank you. Mr. Pickard, you have 19 seconds.
No, 48, I think, Judge.
Oh, I'm sorry, 48 seconds.
Thank you.
No, I think you went over. Yeah, you're
Yes.
over.
I'm over then?
Yes,
Yeah.
yeah,
That's what I thought.
Is there anything you'd like me to respond to?
no need.
Nice
Thank you
try.
to all counsel for your excellent arguments, which were helpful to us. The case will stand submitted and a written opinion will issue in due course. This concludes the oral arguments for our docket this afternoon, and the court will be in recess.